Welcome to Trial Talk, insights from experienced New York trial attorney Michael Joseph.
Hello, everyone, and welcome to Trial Talk, insights from legal expert Michael Joseph. Today, we're joined by guest John Tait, an associate attorney with the firm who focuses on civil litigation, including personal injury, product liability, construction, and premises liability cases. John has an extensive experience handling cases involving defective equipment, consumer products, and complex injury claims in both state and federal courts. My name's Sean O'Connor, and today we're talking about defective products and when manufacturers or companies can be held responsible when something goes wrong. John, how are you? Good to see you.
Good to see you, Sean. Thanks for having me on.
You bet. So, when someone is injured by a product, what do they have to show for that situation to become a legal claim?
Well, Sean, in New York, a party injured as a result of a defective product may seek relief against the product manufacturer or others in the distribution chain if the defect was a substantial factor in causing the injury. A product may be defective when it is defectively designed, contains a manufacturing flaw, or is not accompanied by adequate warnings for the use of the product. Plaintiffs are not required to prove the specific defect, and proof of necessary facts may be circumstantial. A plaintiff needs to show that the product did not perform as intended and exclude all other causes for the product's failure that are not attributable to the defendant. Similarly, when someone is injured by a product, they may also have an implied warranty claim. It's not just strict liability product defect. To show an implied warranty claim, the plaintiff must prove that a product is not minimally safe. They must show that the product was defective or not fit for its ordinary purpose when it left the defendant's possession, is being used in the purpose and the manner intended, and of course the defect was a proximate cause of the plaintiff's accident. That's kind of key because to show proximate causation, the plaintiff must show that the incident that harmed the plaintiff was of a kind that ordinarily occurs as a result of a defective product, and it was not solely the result of causes, other than the product defect as it existed at the time of sale or distribution.
Got it. Well, are there main ways a product can be considered defective under the New York law?
Yeah, it's pretty universal throughout the United States. It's federal law as well. There are three main product defect cases. Those are the manufacturing defect cases, the design defect cases, and of course, the failure to warn. A manufacturing defect is when the product does not live up to the expectations or the designs of the manufacturer. It's predicated on a defect within the manufacturing of the product itself. A plaintiff must show that the product did not perform as intended and that the defect was there when it was purchased by the plaintiff. As explained by the New York courts, manufacturing defects, by definition, are imperfections that just inevitably occur in a very small percentage of products given the design and the result of the fallibility of the manufacturing process. We expect for every product made that one or two will slip through the cracks and there'll be a defect. A defectively manufactured product does not conform in some significant aspect to the intended design. That's also key because every product can come off the line slightly different. That doesn't make it a manufacturing defect. It has to be significant to the intended design. The second one I mentioned, of course, was the design defect. And that's when, a manufacturer is responsible for the purposeful design choices. And any design that presents an unreasonable danger to the user can open that manufacturer and others up to a design defect claim. That responsibility derives from the manufacturer's superior position to anticipate the reasonable uses of its products and its obligations to design a product that is not harmful when used in the manner intended. For a plaintiff to show that, he must show that the product was not reasonably safe. If a reasonable person would conclude that the utility of the product did not outweigh the risk inherent in marketing a product designed in that manner. This is kind of key issues. You hear the word reasonable a lot. And it's up to a jury. Is it reasonably safe if a reasonable person would conclude the utility does not outweigh the risk? All products have risks. All products have utilities. It's a balancing factor that's done by the finder of fact. The third category we talked about, or we mentioned, I should say, is a failure to warn. Under New York law, a failure to warn claim arises when a manufacturer or seller fails to provide adequate warnings or instructions about the foreseeable risks associated with a product's use. A warning must be clearly visible, understandable, and adequately describe the risks. You can't just list what the risks may be. You have to describe them so a person of reasonable intelligence could understand the implications of those risks. This can apply to any number of products, machineries, tools, sports equipment, medicines and chemicals we all know of, but even food at a grocery store requires adequate warnings. And of course, it's strict liability theory, so the plaintiff must just prove the product was not reasonably safe because of missing or inadequate warnings.
So, when we talk about liability, and who can be held responsible for, in a defective product case. I mean, of course, it's like, well, the manufacturer would be held responsible. Are there other parties who could be held responsible for in this kind of a case?
Absolutely. Absolutely. It's anyone in the line of distribution. So as you mentioned, it's manufacturers and even component part manufacturers. Many products will have various parts made up by different manufacturers. Right. So even component part manufacturers, the wholesaler, the distributor, the retailer where you go and you purchase it from, they're all on the hook for a product defect. New York legislature, they put the burden of a defective product not on the consumer, but rather on those best to absorb the societal cost of defective products, and those with the ability to best prevent a defective product from entering the market in the first place. In this case, that's literally everyone from soup to nuts, from part manufacturer to manufacturer, all the way up to the guy in the deli selling you the product.
Yeah, the chain of possession there.
Exactly.
You mentioned, John, a few, several different, categories of products. I'm guessing that there might be certain products that you see most often lead to these kinds of serious injury claims.
It's so varied. There is no one type of product that leads to injury claims. Most of my career was doing product liability work in the firearm industry. And people would think, well, firearms, you'd think there'd be a lot of defects. And it's not. People get injured, but it's not because of a defective product. The serious injuries can come from anything. It could be coming from heavy industry machinery, which is often what we think of, someone losing an arm in a trash compactor. Mm-hmm. Motor vehicles, of course, right? A defect in a motor vehicle, we can see easily how that would cause serious injuries, but it can be household appliances, and even, like as I said earlier, even food products purchased at your supermarket. People don't realize if there's something wrong in that food or, has ingredients not as labels, people can be seriously injured if they have allergic reactions. So we see that as well. It's really, there's no one product that drives, the legal jurisdiction of, product defect in New York.
Got it. So from sort of a trying the case kind of practical perspective, I'm wondering, the sort of challenges that are going to come up, when you're trying to prove something, and provide a, preponderance of evidence, whatever the standard might be. What kinds of evidence are most important when you're building this kind of product liability case? Because I imagine you're up against some pretty well-funded opponents.
Yeah, well-funded and well-experienced. Certainly the defense bar has their firms that specialize in product liability defense, and a lot of them are associated with the products. Like Ford has their guys, and Toyota has their guys and girls, and they're out there fighting every day these issues. Yeah, there's a lot of challenges, and basically the first thing you have to do to address the challenges is determine what type of defect it is, right? Mm-hmm. Is it a manufacturing defect? Is it a design defect? Oftentimes it's both. When the design calls for let's say an aluminum piece that shouldn't be in there because of the stress on it. Well, the piece failed So it's manufacturing. It's also design, because it shouldn't have been in there to begin with. From there, you have to begin building your case. Once you kind of figure out where the defect is, and that's performing product testing and retaining and engaging with experts. Causation is always an important issue, particularly where a finished product may have a number of components from different manufacturers, and where the defect itself may be a piece of the product, but not the entire product. Or the overall design of the product and the way the parts are integrated may be the cause of the defect. So you got to figure out the causation. Another challenge is when the product changed hands after its original sale. Plaintiff must show that the product was defective at the time of sale and not from any changes after the sale or any modifications after the sale. And, you may use a car and you bring it to your mechanic and he does this and she does that. And suddenly it's maybe a challenge to show that that part was the original part. And of course, one of the things people forget is there are usually a lot of defendants with cross claims against each other. Everyone in the distribution chain is responsible, and where the product is complex, and there are usually a number of part manufacturers involved in the final product, so you get a lot of finger pointing amongst the defendants. And as an experienced product liability attorney, you got to work your way through those and go down all those rabbit holes and really uncover what the truth is. These lawsuits often last many years. And it really takes an experienced product liability attorney to uncover the different part manufacturers, the distributions, particularly when you have international distributions, and you got to work through those competing claims. Those are some of the challenges you see with a product liability case that you don't see in other cases.
Yeah, that makes it pretty complex. What about, you've been doing this for years. Have you seen situations where, product appeared to be safe, but later turned out to have a serious defect? And I'm thinking this is probably separate from, manufacturer recalls, which are obviously, publicized and them taking the right steps.
Sure, of course. When a consumer purchases a product, they don't usually see a defect.
Right.
And as you mentioned with the vehicle recalls, I'll take you on that. You'll see if you have a vehicle, you get these recall notices 2 or 3 years after the fact. They say, come in, we need to change this part. It might not be a danger. It might be a leak here. It might be that. And that's something that they've only discovered years later after millions of cars have been sold. And so, these defects do appear later.
Or maybe, they may have discovered the recall may have been initiated because of all of the claims against them. Is that a scenario where it's like, oh, we got a defect problem here and we got to get ahead of it?
It absolutely does, of course.
Yeah.
Of course. And that's, they're risk adverse and there's money involved in defending these. And when they lose, they're going to say, hey, what's it cost to replace a 30-cent part? Even if it's only affected 10% of the cars, let's go ahead and do that. We're going to save money in the long run.
Yeah.
It used to be where you get to recall the car companies. You brought that up. They felt that as a negative. People would think, oh, it's recalled and they lose their value. Although the industry, or really the consumer industry, has kind of changed their perceptions of that. I guess they got so used to, computer programs upgrading and updating
Right.
They kind of accepted the fact that you buy your car now, it's going to need to be updated, just like your Windows computer.
Man, a brand new car today is basically a computer on wheels.
Oh, it really is.
So let's talk damages with the time we have. What types of damages can someone pursue after being injured by a defective product?
All right, so in New York, if a product is found defective and proximately caused the injury, then plaintiffs can seek compensation for economic and non-economic damages. And, economic damages is the money out of your pocket, right? Whether you had medical bills you had to pay, whether it's, money you had to spend, those are your economic damages. If you lost wages because you're out of work, those are economic damages. We call them blackboard numbers. When you're in front of a jury, you like to put down the blackboard numbers. Juries understand blackboard numbers. They can see the number, they can come to a conclusion. The other portion of damage you can recover are non-economic losses, what we call pain and suffering. And, and that's a whole nother procedure, trying to convince a jury and to explain to them what your pain and suffering is, and then for them to put that into a dollar figure. So you get your economic damages and you get your non-economic damages. Now, in New York, punitive damages for product defects can be awarded. It's very rare. They are awarded only when a defendant's conduct is found to be reckless, wanton, willful, or that the defendant showed a conscious disregard for public safety. These damages, they go beyond just compensating the victim. They're designed for punishment. Punish the manufacturers for their acts. They're rare, but they are available.
I see. With the time we have left, I want to, take it down to more of a, I don't want to say practical level, but in a way, right? We've got people listening out there and, maybe they've been, maybe they believe they've been injured, as a result of a product they've used or purchased. What should they do early on to protect their rights? I talk to attorneys that deal in personal injury and, automotive accidents, and there's a list of like, do this, do this, do this, don't do that, don't do this, don't do that. What would your list be, short list, for someone listening that thinks they might have a claim?
Yeah, there's no real short list. One is, I'm going to say probably what every attorney has told you, is call an experienced product liability attorney, because they can understand, right off the bat what you need to do, what the product is. I have products that need refrigeration. We get them stored. A lot of times we can go and get, pre-trial work, pre-trial subpoenas to secure evidence. If it's a product you have in your house, you want to obviously preserve that product in the same condition that it was when it caused the injury. Don't take it apart. Don't try to, take your screwdriver out and figure out what went wrong. Don't touch it. Preserve it. Take any photos or documentation that you have, preserve those. But really, you want representation right away because that evidence is critical. If you change the evidence before the other side has notice and the ability to inspect it, then there's not much you can do after that.
Got it. Yeah, you want to, like we see on TV, you want to make sure the evidence can't be impeached for, well, they took it apart. Maybe they caused the...
It's like a crime scene. Don't touch it.
Listen, great to talk to you, John. We're pretty much out of time here, so we'll wrap it up. But I know we'll talk again in the near future.
All right, looking forward to it.
All right. That's it for today's episode of Trial Talk, insights from legal expert Michael Joseph. If you or someone you know has been injured by a defective product, visit the website newyorktriallawyers.org to learn more about your legal options and connect with the team, including John. Thanks for listening, and don't forget to subscribe, share, maybe leave a review so more people can find the information they need. Have a great day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.